Donald Henry Derby, 25G811, come up to the podium, 75A and B and C. And could I have Bennett seated at the table here? Your name, sir?
My name is Donald Henry Dubry.
Good morning.
Morning.
Is it Dubry or Derby?
Dubry.
How do you spell that?
D-U-B-R-Y. I think it's spelled wrong.
They spelled it wrong on the citation.
Yes.
Lisa, I'm going to go ahead and change that on the file. It's spelled D-U-B-R-Y. Sir, you have a property code violation. You have 3 of them, actually. Storage of unsafe equipment, no protective treatment on home, bare wood, promoting rodent habitat. He says you have piles of junk. 3 misdemeanors. You have the right to a lawyer. Says you've refused to respond to any letters or personal visits. So you have the right to an attorney. If you want a lawyer, I'll give you one. Would you like one?
No,
You sure?
no, I don't need one.
Okay.
I was in the hospital.
Hang on.
I'm sorry.
I'm going to go ahead and arraign you. I'm going to send you to the prosecutor, okay? They think you own the property at 31021 Adams Drive in Gibraltar. And they think that on September 30th, 25 at 10 a.m., that you had 3 different property maintenance violations. You stored equipment, storage of unsafe equipment, no protective treatment on home, that there was bare wood, and you promoted rodent habitation, piles of junk. These are all misdemeanors. And I'm just reading off the citation. They are punishable by up to 500 fines, 90 days jail costs, or all of those. Do you understand that, sir?
Yes, Your Honor.
All right. Did you sign this advice of rights?
I did.
Did you read it?
No.
You didn't read it? What if
I
you,
see the yellow form.
no, this one right here, the advice of rights, plea, this one here, the white form. Don't ever sign something you haven't read. What if you signed your house over to your neighbor? You know what I mean?
No,
I'll
I
cover
just like these 2 yellow things.
He's confused on the copies.
This has got your signature on it, sir.
Well, then I signed.
Come on. Well, let me cover the rights with you. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right at a trial to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt, and there would be no trial of any kind. Do you understand that?
Yes, Your Honor.
All right. Do you still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea for you. I'm going to send you to the prosecutor. You can talk this over with the prosecutor. Okay?
Okay.
And then either way, you're coming back in front of me here. You understand that, right?
Yes, sir.
Okay. We'll see you back here in a few minutes. Good luck. Mr. Dubry. They're going to give you an adjournment. Okay?
Okay.
To comply. Okay?
Yes.
If I were you, I'd start going home and working on it today. I'm only forewarning you. I don't want to talk about whether or not you have a blight condition. You're still presumed innocent. This tells me we're adjourn it for them to schedule an inspection and make sure you're in compliance. I've had enough of people not doing these things with homes. You can't have rodents. You can't have a house that's not properly maintained in accordance with their codes. Do you understand?
I do. You're right.
And now and I don't want you coming in here in 2 weeks and telling me, well, Judge, it was cold out. You knew about this. This says there were numerous warnings. I'm giving you 2 weeks to get a good start. Lisa, and I mean that. I'm not going to be very patient with you. This ticket says here on the bottom, has refused to respond to any letters or personal visits. Now listen, they were too nice.
Yes.
They were too nice. Listen, let's start with that premise. They were too nice. I'm not going to be nice.
If I may, sir. The reason why he thought I was ignoring his warnings because I was in the hospital
How long were you in the hospital?
5 days, and I didn't read my mail for at least 6 or 7.
Well,
Because by the time I got home,
they didn't just pop this on you 5 days ago, or a week ago, or 2 weeks ago. They've been talking to you about this, right? The city's notified you they have problems with this, right?
yeah, but it was a mailing.
Calling the prosecutor. I'm giving you November 6th. You have any kids?
No,
Get somebody to help you if you can. Well, I mean, you can't let your house go like this. Adams is a nice street.
it is very nice.
Nope.
I lived there all my life.
Nobody wants to look at junk. Right?
I hear you, yeah.
Nobody wants to look at junk. November 6th at what time, Lisa?
9:15.
All right, counsel, your appearance.
Anthony Blaine.
How long has the city of Gibraltar been asking Mr. Dubry here? By the way, the ticket's misspelled. It's Dubry, D-U-B-R-Y. How long have they been asking him to clean up the property?
I believe it's been a moment.
How's the moment? How long's the moment?
I don't know the exact time, but he's assuring that by the next court date, he's gonna clear out those tanks that we've been asking to clear out.
How long? You don't know who's here? Does somebody know? Is there a building
I
inspector?
have the sergeant here, we can find out the exact time.
Call him in. I have too many of these cases going. You know that? I don't know why people don't take care of their property anymore.
Well,
Yeah, I'm not saying everybody, I'm not saying most, but more than I've ever seen are not. Let's just put it that way. So I'm gonna ask the sergeant, and I'm gonna find out, and then we'll go from there. But that is going to be your next court date, November 6th at 9:15.
that's,
If you want a lawyer going forward and you cannot afford one, you can fill out a petition for a court-appointed lawyer. Do you understand that?
I do.
Okay. Because you're entitled to one at the arraignment, you waived it, but if you want one going forward, I have to have evidence that you're indigent, all right, that you can't afford your own anymore. So that's where we are with it. I think the sergeant's in there, right? All right, Sergeant, your name,
Here,
how long have they been notifying Mr. DeBry here to clean up his property? Do you know?
just over 2 months there.
Okay. Mr. DeBry, just make some strides, quick strides. You can start today, you can start tomorrow, you can finish it by Sunday if you want. Let's get it done. I'll see you November 6th. You can go down the hall, get your notice. Any questions?
No.
Good luck.
Thanks, Your Honor.
Thank you. Joshua Michael Zarati, 25F2433398. Come on up here, sir. Your name?
Joshua Michael Zarati.
I placed you on probation on May the 15th of 25. You had pled to operating while impaired. I now have a probation violation here that alleges you violated probation. The probation department thinks that you failed to refrain from consuming alcohol or drugs, testing positive for alcohol on September 29 and 25. That would be a first technical violation. If you plead guilty or if you're found guilty, you could get 5 days in jail. Do you understand that?
Yes, Your Honor.
Did you sign this advice of rights, revocation, and probation?
I did.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes, Your Honor.
You have the right to an attorney. I'll be happy to provide you with one at public expense. Would you like a lawyer?
I would, Your Honor.
I'm sorry.
I would, Your Honor.
Okay, I'm gonna go ahead and enter a not guilty plea. We're gonna go ahead and set you up with a lawyer. I'm entering a not guilty plea.
Is this a court-appointed attorney, Your Honor?
Yes, sir.
Okay.
Okay?
I'm sorry, can you just repeat the non-guilty?
I'm entering a not guilty plea. We're gonna set you up with a lawyer.
Okay,
Go talk to the lawyer. After you talk to the lawyer and you will come in here and we'll handle this.
okay, Your Honor.
Is that all right?
Yes.
Did you want to go hire your own?
No, I didn't. I just wanted clarification.
Okay, no problem. All right, go out in the hallway. He'll set you up with an attorney.
Okay,
Thank you. Mr. Zarate, come on up here. Tell me your name.
Joshua Michael Zarate.
Mr. Gabe,
Good morning, Judge, man. This was all right.
what's he going to do?
We're gonna pick you up with.
I need somebody for Beth. If you plead guilty here, sir, this would be a first violation. And your probation, not your probation could be revoked. I need Beth or somebody for her. You could get 5 days on this by pleading guilty. Do you understand that?
I do, you're correct.
Did you sign the advice of rights, revocation, and probation?
Yes.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, Your Honor.
You understand all your rights.
Yes, Your
The
Honor.
charge you fail to refrain from consuming alcohol, how do you plead? Did
Guilty.
you test positive for alcohol on September 29 or 25?
I did.
Did you consume alcohol, say, within the 3 days preceding that?
Yes.
What did you drink?
Just beers.
Well, Beth's off. I need somebody for her. How many beers? Where? Where?
Oh,
It was at your house, where was?
oh, it was at home.
Were you by yourself?
I was.
Nobody else there?
I live with a couple of people, but they work.
So what did you do? Go up to the store and buy beer?
There was just beer at the house.
Well, who put it there?
One of them.
I think it's roommates.
Well, that isn't nice. You're not supposed to be around alcohol either, you know. So you just went and started pounding beers.
Honestly, Judge, there's no excuse for it.
All right, good enough.
I
If I may, Judge, just as Mr. Zarati's mother was just recently admitted into a group home where she's suffering second dementia.
Oh, geez, I'm sorry.
And
That's all.
turns out her husband, Mr. Zarati's stepfather, had been embezzling money from the accounts.
Nice.
Without knowledge, and kind of, he's been getting calls from the home telling him that.
How can he embezzle money? He's not on the accounts?
To be honest, Your Honor, I'm not 100% sure about this about how he has been embezzling the money. I've just been told that he has been by the staff. She's like a financial advisor at the group home. She talked with my brother's wife.
Okay, you guys figured that out, but
That was the reason why Judge, she kind of fell off the wagon, so to speak. He's been getting a lot of calls from that group home, and his mother's been
you just
uncomfortable at that place, and she's been trying to.
went on monthly testing, right?
Yes. Starting, I want to say October 1st.
Otherwise, I believe Mr. Zarate has already completed all of his other conditions, and he does have, out of the 1355 originally approved, I believe he's got a balance of 455 that's still pending. So he's made a good effort to pay off a substantial amount of that balance for the oath. He had assured me that he's completed all other conditions of his probation. Isn't that
All
right?
right, you've been doing well. Serve 8 hours of community service. That has to be completed by November 25th.
Okay, Your Honor.
8 hours, nonprofit organization, pay additional costs of 100, and you're to test bi-weekly during the duration of probation. Okay, you're gonna have to go meet with probation. John, tell them they don't have to come here. And you're gonna sit down, they're gonna change your color, and they'll answer any questions you have. Can you pay that $100 now?
Can't start tomorrow. I get paid tomorrow.
I'm just gonna say, pay this by November 6th, okay? So go into the probation room, John, take them over there, and you're all set. Good luck. Dakota James Bennett, 24W8348538. Mr. Bennett, your name? I placed you on probation. Actually, I did not place you on probation. This was an operating while impaired. I simply fined you and ordered you to complete community service. $16 hours by March 1. And I have a charge here that alleges you failed to complete 16 hours of community service by March 1. If you plead guilty or if you're found guilty, since you absconded.
Yeah, I'm not too sure what's really going on with it, because I paid all my fines.
Stop, just let me explain, okay? You were supposed to come in here for a show cause on this charge. Failure to provide proof of completing your 16 hours community service by March 1. We set it up for May 22. You didn't bother showing up. A bench warrant was issued. You came in and paid in full. But you had an outstanding show cause violation. So if you plead guilty here, if you're found guilty, I want you to understand that since you absconded, actually, I'll count you not having absconded since you came in here on June 10th. I'll take that as being our fault that occurred, but I don't think it was. Because I'm gonna read it to you. Defendant paid in full, June 10th. Cashier canceled warrant by filed case on probation shelf, not realizing defendant had an outstanding show cause. Defendant video ring on new Judge Hesson case, set this case on same day as new pretrial with Judge Hesson. So I'll just tell you, you could get 5 days here. You understand that? And did you sign a yellow advice of rights revocation of probation? Did you?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial of any kind. You understand that?
Yes, sir.
All right. You have the right to a lawyer. If you want a lawyer, I'll give you a lawyer.
Thank you.
I'll enter a not guilty plea for you.
Thank you.
Indicate you stand mute, set it for a revocation hearing. You can go out in the hallway. We will set you up with an attorney. You'll come back in front of me today. Do you understand that?
Yeah.
Do you have any questions?
Not bad indeed.
Okay, you can go right out in the hallway. Good luck. Bennett, Dakota James Bennett, 24W83485-3A. Mr. Bennett, your name?
Dakota James Bennett.
Good morning, Judge. I'm David Spring, you have to meet with Bennett.
I need Jessica. All right. Make sure they know they don't have to send me anybody on that last case. How's he going to proceed?
Judge, you gotta plead not guilty. According to Mr. Bennett, he completed the 16 hours, it was just the issue of data verification
Alright.
by his probation officers, that would be illegal to her direct.
He wants a hearing as to whether or not they sent it. Is that what you're telling me? If he does, that's fine.
According to Mr. Bennett, he's already spoken to probation officer, who was Ms. O'Donnell, and she did assure him that the verification would be emailed. Is that correct? That's why he failed to provide it to. Verify that it was O'Donnell that does.
Ms. O'Donnell, come on up here. Your name? Did we ever receive his proof of completion of 60?
People's Proof of Community Service, I actually gave him 2 different extensions. I gave him an extension till March 31st of 2025, and then he called me again and needed more time. I then gave him till April 30th of 2025, and then I issued the show cause after that. 'Cause I never received anything.
All right, so do you want to have does he want to have a hearing still?
You must sign it.
I mean, I would like to play my case for it, yeah, because I went and did it.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I figured so.
Okay, go ahead.
So I have 1 violation listed for the defendant. Number 1, failed to provide proof of completing 16 hours of community service by March 1st of 2025. Again, like I said, stated earlier, I gave the defendant 2 separate extensions regarding his community service. I initially gave him until March 31st of 2025 to complete his hours and turn them in to me. He then called me again and asked for more time. I gave him till April 30th of 2025. I have yet to receive any kind of proof since then at this point, and I haven't heard from the defendant.
Any questions of him?
Judge, no, I would,
Does he wish to testify?
no, if I may, Mr. Bennett's gonna change his plea, Judge.
Well, that's okay. I've heard the testimony. I'll go ahead and find him guilty as charged. I mean, there's no contrary evidence.
He, according to Mr. Bennett, Judge, if I may, says that he's got an email confirmation, but it's in his other email, which he doesn't have access to. I did advise him that he needs to have that today.
I So all I know is I went and did the hours.
Where?
I want to say it's called Victory Gym.
You don't remember?
It was long ago and I thought.
Do
it
you,
was
do you
done.
do a lot of community service?
No.
Have you been in other courts?
No.
What do you want to say? I want to say it's Victory Gym a long time ago. This wasn't in 1896. This was 5 months ago. Come on. You called her up twice. You asked for an extension. She gave it to you.
Yes, sir.
I don't know what you're doing here, but this is not do it as you feel like. Are you this irresponsible with your everyday affairs? Well, come on, don't tell me this nonsense. I want to say it was Victory Gym, like there's a question in your mind as to where you did the community service. Why don't you just admit, Judge, I never did the community service.
Did do the community service, so.
Okay. I'm finding you guilty as charged for, hang on. I'm finding you guilty as charged for failure to provide proof of completion. I'm giving you 2 weeks to come back here with your proof. Okay, listen to me.
This is what the judge.
Now you're dancing around.
Nervous and scared. I know the proof of it, but I know that I did. That's all I'm saying.
Let me finish, you'll understand.
You're going back to Victory Gym and you're gonna ask them to give you proof of it.
Yes, sir.
Now, in the future, you need to be more responsive.
Yes, sir.
I just got done listening to her tell me that, and I gave you till March. Let's start it from the beginning. I gave you till March 1 to complete it. It was only 16 hours. I sentenced you January 22nd. She gave you 2 more extensions for a couple of months.
Yes, sir.
And now you come here and you're telling me, well, I want to say I did it at Victory Gym. Like, just admit that you didn't do it. Because when I tell you to do this and you come back with some cockamamie story with me, I'm not going to be a happy guy. I don't believe people should be lying in court. Do you want me to adjourn it so you can go get proof?
I'd like to try this, sir.
Okay, we're going to set a sentence date, November the 6th. What time, Lisa?
9:30.
At 9:30. Defendant to bring proof of completion. I mean, where do you work at?
Straight.
What kind of charge was this? I mean, I didn't even do anything to you. I was more than fair with you. I didn't even place you on probation.
No, he didn't acknowledge that, Judge.
What? Maybe that was my fault. I mean, they encourage us, the statute says they're not to be on probation unless the judge departs and says reasons why. Let me see the screening. Do you have it?
I'm sure it'll be gone.
Geez, I only fined him $884. Something was. Okay, at a .09 and a .10, and he's 27. I still. God, I didn't even make him do any of this. All right, that's what I'll do. Come on back with your proof. Okay? You must comply with all other terms and conditions of probation. November 6th, 9:30. Go down the hall and get your notice. Good luck. Thank you. Jacob Kelly McSuch, 23T640501.
Good morning, Judge. I'm here to turn that one to Massage, who's in the switch.
Mr. Masuch, come on up to the podium, please. Tell me your name.
Jacob Mason.
It's Massage. Okay. All right. So, sir, he pled guilty to assault or assault and battery. Actually, he pled no contest.
Correct.
I want to know right now if there is an Adam Forstall here, either on Zoom or in person. Is Adam Forstall here?
Not on Zoom.
I need to know before we go on what is going on with the relationship here. This was
Mr. Massage, I apologize. Mr. Massage was in a relationship with Mr. Forstall's stepmother.
Right.
And the argument ensued while the parties were living all the same residence, judge. All came down to an issue with the animals, and they were actually defecating and urinating in the children's playpen. So they were moved to the upstairs bathroom for the night. The next day, the mother came out, was upset that the cats, or the dog was put into that bathroom. An argument ensued between her and her daughter. Mr. Masuch came upstairs and kind of tried to straighten things out. Things kind of got out of hand, and Mr. Forstall got involved, and there was an altercation between them.
Okay. What else? I saw that happened. I just wondered, I read the report, but I
They're
just,
no longer living in the same residence. And he's no longer with the, Miss, Rellinger.
okay, good enough. Everything else in the report is accurate.
Everything else in the act, we've had a chance to review, Judge. We have no corrections and deletions. Judge, I would say that Mr. Message is 26 years old, Judge. He's a single father. He does have 3 minor children. He is full-time employed, Judge, with All American Enterprises, where he does construction and handyman work. He's had steady employment for at least the last year. He doesn't have any criminal history, Judge, other than this pending case and a moving valuation back in 2023. So Judge, he doesn't get in trouble. Overall, at this point, all he cares about is just going to work and he takes care of his kids. And he understands that maybe there was tempers got out of hand that day and things could have been handled better, but and now he just wants to do whatever the court sentenced him to, Judge, and to put this behind him. And I believe he'd like to address the court as well.
Fair enough. Sir, what would you like to tell me?
Want to apologize for my actions. I could have handled the situation a lot better than I did. And I want to get the whole situation behind me and move forward from it.
10 months probation per the agreement. I just saw that it's taken under HIDA. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, home telephone number, you must notify probation. You have to report as directed. You're to obtain and maintain employment and provide proof of that. You do have to obtain a high school diploma or a GED. You need to do that for you, not me. No contact with Adam Forstall. You're gonna write, phone, see, text, email him, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. None of those. Do you understand that?
Yes, sir.
You're to clear all your warrants by November 7th. They're recommending 30 days. I'm gonna give you 2 weeks to go clear all those warrants. Do you understand that?
Yes, sir.
Anger management with 8-week follow-up, no contact with the victim, no firearms, no dangerous weapons. 3 days on the court work program. There's a $35 a day charge for that for a total of $105. You're gonna pay fines in the amount of $100, costs $175, $75 victim's rights fee, $50 justice assessment. So your fines and costs are $400, probation fees are $200 for $600. Screening fee is added in. And the court work program fees, everything included is $765. You pay that, you stay out of trouble. We'll give you a review hearing date. You'll come back here. At that time, we're gonna give you one for sometime in 2026. It'll probably be early August. We'll give you that date. You're gonna go down the hall, get that date in paper on your paper notice. Then you go meet with probation. We'll explain the order. Do you have a review hearing date, Lisa?
August 13th of 26 at 9 o'clock.
August 13th of 26 at 9 o'clock. Can you pay all these fines today?
Judge, there's a $300 bond that was posted on this case.
Okay, that was, let's see, I believe that's a 10%, yes. So he has 270 to apply. I just want to make sure it's in his name. It is. So he has 270 to apply. How much more do you have with you?
Yeah,
Nothing was good. I got paid tomorrow.
How much, do you get paid weekly or bi-weekly?
Judge, if I may, what is the remaining balance?
275 from 765. So what's that? 465, 490.
Did I get the payment bond?
How much can you pay per week?
30, 40, 50 bucks, whatever you're okay with.
$40 a week, and I'll start you on October the 27th. If you ever don't have the money and you're gonna pay $275 now, that's simply, or wait a minute, $270 now. $270 now, so the balance will be more than that. It will be, let's see, $395.
$495.
$495. Okay?
Judge,
If you ever don't have the money on any of these due dates, no problem. Don't worry about it. Call the court. We'll go on or before the due date, 8:30. I'll be glad to give you an extension, okay? Just don't ignore me.
Judge, would the court consider early termination if Mr. Message was to?
I will always consider early termination. It's a question of whether the prosecutor is willing to dismiss it at that point. I leave that to them. I mean, I don't care.
Can he ask
Most
for
of
a
them,
review after 5
yeah.
years? Or-
Yeah, as long as he's got everything done, there have been no violations within the preceding 90 days.
Understood.
All right, you got it?
If you want the violation within 90 days after 5 months.
You can apply for early discharge and then talk to the prosecutor about dismissing the case, okay? All right?
Yep.
Good luck.
No,
Abraham,
thank you, Judge.
Thomas Patrick Abraham, 24W8330005.
Good, one of the articles, we should get ready back to my final approach. Do we want to get that estimate?
Yeah, call Jessica.
Should be here then in like 30 seconds.
Yeah, I know, she's great. Your name, sir?
Thomas Abraham.
All right, so we set a sentence for today. He has been struggling. This is with regard to the show cause dated October the 9th. And I have another one here. Yeah, I'm not sure. What do we do on this?
We've adjourned, I mean, he submitted responsibility, then we had adjourned.
I don't think he admitted, did he?
Yeah, there was a moment where we had to go through, just clarification, but, yeah, he's admitted,
All right, I gotta refresh myself. Your name?
That's what.
I said a sentence on this. He's got 5 counts here. Did I take pleas to all those counts?
I believe so, yes.
And I didn't write it down?
Yeah, you took pleas to all counts. We did just miss count 1 though.
Okay.
That's what I have listed from the last hearing, which was October 16th.
that's accurate.
All right, I need another probation violation sheet here. Like something happened. All right. So you're saying count 1 was dismissed as part of the show cause of October the 9th. It was scheduled for the 16th, 1 week ago, right?
Correct.
Then defendant pled guilty. Just give me 1 second, please. So count 1 was dismissed. I'm going to prepare a register because obviously if I did, I didn't do a very good job. Oh, wait a minute. Wait a
I'm
minute.
sorry.
Wait a second. Wait a second. I see what happened. All right, my mistake. He pled guilty. This just didn't get stapled to the register here. Count 4 was dismissed on your motion.
That's correct.
I accepted the plea to count 1, 2, 3, and 5. That was cocaine metabolite. Number 1 was a positive test for cocaine.
That's correct.
Count 2 was a positive test for a cocaine metabolite. Count 3, failure to refrain from consuming alcohol or drugs, positive for cocaine. And count 5, failure to submit to testing as ordered on September 30 of 25. Why did I adjourn this a week?
Under this circumstance, I asked for 2 reasons. First, to show that he was going to continue to test negative, which he did reflect 7 negative tests. And secondly,
He tested negative?
for the last 7 tests, yes, Your
Is
Honor.
that right?
That's correct. He appeared for test and every test was appeared in that 7th test since October 5th that he appeared for.
Okay.
And another issue that the court took into consideration, which we were very thankful for, was my client was closing on a house that he was able to successfully do on October 17th.
So, okay.
And I had further allocution.
Did we talk about sobriety court?
Did, the team voted no on.
Yeah.
It was, I think, regarding count one being the fact that he brought in outside urine in for that test, and that was regarding why he was.
What do you want to say?
Your Honor, I will note on the positive that he is reflecting a negative test. He is in the guidance center 3 days a week. He is attending AANA 3 to 4 times a week, seeking a sponsor. Judge, he's a dedicated father at this point to his 3 adult children, 34, 31, 27. He's also dedicated to his grandchildren at age 13, 9, and he has another grandchild due on November 11th. On his work as a CDLA and he assists in tree removal. Judge, he discarded all the toxic friendships and relationships he had that were adding to obviously his questionable behavior, but I know a little bit later than we would have anticipated or wanted him to start, but he's starting to accumulate some success in his sobriety, and it's anything that we can do to help encourage it would be greatly appreciated by the court. As I indicated, my client's not working. He's retired for 29 years as a Delta bag handler, which I think did lead to prescribed medications, which took him down this road. Just hoping that he's emerging.
Why did that lead to prescribed medication?
Well, he had back injuries.
Okay, that's what I thought you were alluding to. That seems like a tough job. I mean, at least at my age. Okay, what do you think here?
So again, I think he was a good candidate for sobriety court. I really thought that was the best option for him, but considering that he won't be applied in it now, I am a little concerned just because being on regular probation, the testing and kind of some of the guidelines is not going to be as strict as sobriety report would be. And I worry with him that if we, especially while we're testing down and things like that, he's going to start testing positive again, is my concern.
Your Honor, as far as regular probation, is there a way that you can have regular probation adopt some of the conditions of sobriety court?
We can't pay for anything. That's the problem. That's the problem.
As far as splitting the baby to at least sidestep the potential for time in custody or having re-screened for sobriety court. I mean, in the meantime, he's at least doing negative tests, but anything the court would like to consider, my client is more than willing to adhere to.
I mean, it's only 3 months old. Mr. Abraham, what do you want to say?
I'd like to say that I got much to be thankful for and to live for. I don't wanna go backwards in any way. I closed on the house. I've got a grandson coming, my first grandson, and I'm willing to, give him my best shot. I don't want to disappoint myself or you or the court. I just want to continue.
All right, I've heard enough. Let's adjourn this. Let's try to get him back in sobriety court.
You want to try that again?
I do. You pull any more of that nonsense with bringing in urine or missing tests. If you're not successful in the next 4 weeks, I'm not going to take you in sobriety court and I'm going to send you to jail. Do you understand that?
Yes.
At least I'm starting to see that maybe, just maybe, you're showing a little bit of interest in getting off of that junk. Well, give me about 4.5 weeks, Lisa.
Do you want to do a sobriety court day?
I want to, we're going to set him back and see if he can try to get through the bond phase of sobriety court. You're to comply with all of the terms and conditions that they tell you to. And then we're going to set it out long enough where the team can evaluate to see how it's done and make a determination as to whether or not we should accept them.
Okay, November 26th at 8:30.
I think that's enough time. November 26th at 8:30. That's the day before Thanksgiving. So you do what you got to do. You go talk to Ms. O'Donnell. She'll set you up with sobriety court people, probation officers. We'll go from there. Go down the hall, get your notice. You're still on thin ice with me. You can't bring in urine. That's ridiculous. I mean, that alone causes me to say I should be sending you to jail. But at least you're, looks like maybe you're trying now. I'll give you the benefit of the doubt, but don't hold your breath. If you violate again, I'm telling you, Mr. Abraham, I don't want to threaten you. I'm telling you, you're not going to like what I'm going to do. Okay?
Understood. Thank you.
Good luck.
Thanks, Judge.
Thanks, Mr. Shumke. Thank you. Gibraltar LLC.
Thank you, everyone. Yep.
25G86827776. Your name,
Justin Weiss, member of Raj Gibraltar LLC.
counsel, your appearance.
Scott Osmacher on behalf of Raj Gibraltar LLC.
This is going to be a bench trial.
Yes, Your Honor. Where I
All right.
defer to prosecutor.
What is your position with Rise of Gibraltar LLC? You,
A member,
and I'm sorry, your name again?
Justin Weiss. He was the only one of the other members of the Plea LLC.
Ronald
Thomas.
Thomas. Did you say Vice?
Weiss, he is in boy.
And what do you do there?
One of the owners,
This is a corporation, true?
LLC.
Well, it's a corporation. Are you the president, vice president? What are
A
you?
member.
I don't know what that means. I mean, are you a shareholder? I really want an office holder here, Mr. Ossenmacher, but I'll take this waiver. You're authorized to waive this jury trial demand on their behalf, right?
Yes.
And do you understand that the company has a constitutional right to a trial by jury? And if you waive that right, I'm going to be the one who will solely decide your guilt or innocence instead of 6 people that would be impaneled?
Yes.
Anybody force you to do that?
No.
If you can, and you waive your right to a jury trial, right, counsel? Mr. Bologna?
Yes, Your Honor.
If you can make sure that you have these guys fill out these waivers in the future, that would be better. I'm going to set a bench trial, waivers accepted. We'll give you a bench trial date,
November
What do you-
20th at 1.
November 20th at 1.
Your Honor, could we get a little bit more time? We have a potentially complex defense that's going to require some investigation and extensive investigation into the history of this property, because we need to prove a prior legal non-conforming use, which may require us to track down.
You know what
multiple prior
agitates
owners.
me though a bit here? Mr. Ronald Thomas appeared on August the 14th. I told him he needed to hire a lawyer. We set it for the 28th. They didn't show up. We set it again for the 11th of September. They didn't show up. I said for the staff to issue a show cause against the president. So they've had here months that they've known about this. So I'm not going to give any more time. This is crazy. I mean, I don't understand why this president made me beg him to get a lawyer, and I'm not going to beg him. Sorry, it's nothing against you. November 20th at 1 o'clock. That will be the bench trial date. If you guys want a final pretrial date before then, I don't have a problem. I'll set it up then. We'll see how everything's progressing. If you want, if not, I'll just set it for a bench. It's up to you. I'll tell you what, Mr. Ossenmacher, when did you enter your appearance?
I entered my appearance on
October 9th.
Why did you guys play such a game with me? Mr. Thomas, I don't appreciate that. I don't appreciate that. I'll do this for you, Mr. Ossenmacher. We'll make November 20th, if that's the same time, Lisa. We're going to do it as a pretrial. I don't know if it's just an afternoon docket, if it's going to be a final pretrial. We can do
No,
it
we can do the
earlier.
morning. I just did
Okay.
that because I thought it would be lengthy.
I understand. What time should we do that?
9 o'clock.
At 9 a.m. And then I'm going to give you a bench trial date. I'll do that for you, counsel. That's not your fault that they were out of control as far as I'm concerned. Bench trial, that'll be the final pretrial. And then the bench trial date will be on,
Gibraltar's here December 4th and December 18th.
what do you want? What do you want, Mr. Ossenmacher? You want till the 18th? If you've got a defense, I have no issue. If you want, tell me the 18th. I'm fine with that.
the 18th would be preferable. I do have a conflict on my calendar on the 4th.
I'm sorry, you have what?
I have a trial tentatively scheduled.
No, that's fine. We'll do the 18th. Lisa, at what time?
1 o'clock.
At 1 o'clock, okay? 1 o'clock. All right, so you got to be here November 20th at 9. I'd like Mr. Thomas here. He keeps acting like he's the president or something. I mean, of the country.
We'll make sure
I
that
can't
Mr.
believe he
Thomas is-
acts this. What do I say? He's this aloof about this. I want Mr. Thomas here.
We'll make sure
Okay?
that he's there.
Yeah, make sure he's here. I'm not real excited with him. He's gonna have to show a slight amount of respect anyway. So he's gonna be here, okay? Tell him I want him here. You understand? All right, so November 20th, December 21st. It wasn't your fault, so I'm good with doing this. Have a good day. Thank you.
Thank you, Honor.
Samuel Lee Hill. 25W727451. Mr. Hill, come on up here, state your name.
Hill.
On February 4, 25, I sentenced you. And now I have a charge here, and I took this under 7694A. I have a charge that you failed to attend and complete the domestic violence program with 12-week follow-up. That is the charge if you plead guilty. If you're found guilty, this would be a first violation. You could get 5 days. Do you understand that? You got to keep your voice up. Did you sign the advice of rights and read and understand the rights?
Yes, Your Honor.
Keep your voice up. Can you keep your voice up for me?
Yes, Your Honor.
All right. If you plead guilty at any time, you're giving up all those rights. There will be no hearing. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to give you one at public expense if you want one.
Yes, sir.
Would you like a lawyer?
Yes, sir.
I'm entering a not guilty plea for you, indicating you stand mute. We're going to give you a lawyer. You'll go meet with the lawyer, and then either way, you're coming back in front of me with your lawyer right now, okay? When you're done talking. Any questions?
No, Your Honor.
Okay, go talk to the lawyer, and then when you guys are ready, come on back in. Thanks. Do we have anything on that, Mr. Derby? Or DeGray, I'm sorry. I'll take it, Timothy. Thanks. Donald Henry Dubry.
Yes, Your Honor.
Come on up to the podium. File 25G81175A, B, and C. Your name?
My name is Donald Henry Dubrow.
Sir, your name?
Good morning, I'm Samuel Hill.
All right, so how's he going to proceed?
Your Honor, my client's going to plead guilty to the going violation with explanation.
We're gonna need Jessica in here. Is that what you want to do, sir?
Yes, sir.
If you plead guilty, you could get 5 days. Do you understand that?
Sure.
Did you sign the advice of rights, revocation, and probation today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, Your
To the charge that you failed to attend and complete the domestic violence program with 12-week follow-up, how do you plead?
I plead guilty.
Did you fail to attend and complete the domestic violence program with 12-week follow-up?
Yes, sir.
Anybody force you to plead guilty?
No, Your
Did you ever start it?
Yes, Your Honor. I will not start it, but I
You know,
paid
Wilson.
for it. I paid for it, Your Honor, and I just, been so busy with work and
You're
He did
working
not
on,
attend yet, Your Honor. He had paid for it and scheduled for the 8th, and I'll explain why he missed that date.
go ahead.
Well, Your Honor, again, my client's hardworking and he's got 2 jobs. And he works at Kroger's, and he works at maintenance, especially does a lot of concrete work, 70 to 90 hours. But more importantly, the sister was in a terrible car accident recently. It was a truck. I think she needed back surgery
knee
and
surgery.
knee surgery. And he was there as kind of supporting. We just kind of lost track of that date. Once he missed it, couldn't get started. He asked for reschedule, Your Honor, for December the 12th. The issue is that it's right at the end of his probation. So she's hoping to get it extended so he can enroll in the class.
I don't understand when I ordered you to do this in February. This is October. That's 8 months. You're about 8.5 months out.
Your Honor.
Well, why are you taking so long? I don't intend for somebody to do those at the end of probation.
Yes.
To be honest, Your Honor, it's,
I want you to be honest.
with me, I had got a new car, with the job.
You're a big shot, eh? They're giving you a new car?
No, actually,
You bought yourself a new car.
I bought myself a new car, yes, sir.
And then
To get back and forth, the house.
this is the opposite of not having transportation. So you had transportation. What was the problem?
Payments, I was, with my credit being the way it is, the car payment's $575 plus full coverage. I'm thinking they're paying close to $1,000 and, helping out family.
So again, right, that's why he's working so hard. So, because he's got all.
What kind of car did he get?
I got a 2020 Chevy Malibu.
But when you got bad credit, I mean, in Michigan nowadays, you end up paying easily $600-700 for that.
Man, listen, I get it.
Insurance.
You have to convince me.
So the court understands his financial issue. So he had a high and imperative to work, get this second job, work as much as possible. And when his sister got hit and the family popped up, he just got really spun around, in terms of his timing and availability. Again, he's willing to do it. He knows he's obviously late to the plate, but he's just hoping to give him a few more weeks. He's signed up. He's ready to go. Everything else, he's on track. For those $355, he's going to pay $55 today. He'll get the money paid. That won't be the issue. Just a few more weeks so he can finish it.
What are you doing? Praying?
Basically,
Ms. O'Donnell,
Just put on.
what do you think here?
My only concern is that, so he was scheduled for this program back in August. He failed to show up in August, and then they re-changed it to October for him.
Alright.
He failed to appear in October. We've now changed everything. Now he is to appear in the next available class, which is December.
And he's not gonna be out probation.
He's not, and he's under that deferral status.
I'm gonna cut you a break, but don't dilly-dally. I'm telling you, I'm gonna extend your probation for 3 months until May 4th. You're gonna pay additional costs of $100.
Yes, Your Honor.
You're gonna pay additional probation fees of $60.
Yes, Your
You're
Honor.
gonna serve 1 day on the court work program and pay $35 for that, so that's $195. I'm gonna give you all the way. I'm gonna give you all the way until December 1st to pay these, okay?
Okay, Your Honor.
And you're to complete the domestic violence program with 12-week follow-up.
Yes, Your Honor.
What's your question? Yeah.
So, the court work program, will it be on the same days? I work Thursday through, Sunday. That is my main.
You
job.
could do this on Wednesdays.
Yes, that's perfect.
We still have one on a Wednesday for you,
Thank you.
okay?
Yes, Your Honor.
Review date then, please. We're gonna extend him. His current review date is scheduled for January 20th of 2026.
Oh, this is under 769, yes. My mistake, yes. Lisa, let's get a new review hearing date. Probably, let me just double check something here. The new review hearing date, Lisa, I guess,
April 29th at 9 o'clock.
April 29th at 9 o'clock, okay?
Yes, Your Honor.
April 29th of 26 at 9 a.m. Okay?
Yes, Your Honor.
You do that, you comply with all this, the case will end up dismissed.
Thank you.
Good luck.
Thank you.
Thanks, Crawford.
Okay, so the people versus Theophilus Smith. Your case.
I just felt with people.
Very important, I'm married.
Theophilus Smith.
Yes,
I've got you, Mr. Smith. I'm waiting on your attorney. Whose case?
yeah, who is the attorney?
Mr. Brown's case.
Yeah, I would like to fire my attorney immediately. I like to
Of
fire
course
my
you would.
attorney, fire all representation.
All right, we'll get to that in a minute. Maybe he knows already, which is why he's in here.
Sorry about that. Okay. Norm Brown, Deputy Chief Public Defender, being on behalf of Mr. Smith.
So that you're aware you weren't in the courtroom, Mr. Smith did identify himself, so I'm not going to ask him to do that again. And he indicates that he wants to fire all his representation.
I understand, Your Honor. Has the court received an updated competency report?
October 22nd.
Yeah, I speak on that because I'm representing myself.
The report. The last report I have is from July, but it was
No, the only report. the only
marked that
copy I
we
took,
received
Judge
it.
Simpson,
The only
on
conversation I took was
October
on February
22nd, but
22nd.
I don't know that
February
that, okay,
27th.
Mr. Smith, we both can't talk. Okay, I'll hear you, but we both can't talk right now. All right.
Your Honor, we have,
I don't know if that, so to finish that thought, I don't know that this is an updated report because it's dated July.
Right.
Maybe you have 2 week adjournment so we can try to figure out. How
2 weeks.
so I will
Sure
say.
you don't want more? No, go ahead.
I will say this for the record. Your Honor, I believe the last report has indicated that Mr. Smith has not yet gained competency. So I'd ask the court to not fire me from his representation. To not fire me from.
No, I'm not. Yeah.
Thank you. Thank you.
You already knew what my decision on that was going to be. What I'm going to do, Mr. Smith, is I'm adjourning your competency hearing. We need to get more information and then I can act on whatever you may want me to act on. But yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent me. I will no longer want a public defender like him. I do not want him. He haven't been to see me. He don't know none of my angles. He don't know anything. And first of all, I do not need a competency exam for a $1 prohibited fire act case.
Well,
the case is arson. It's only a case that I burned the box. It was only a $1 box that got prohibited. It was a prohibited fire act. The smallest. I do not need a competency exam for that.
Okay, so Mr. Smith, I can't do anything till I get that report.
Well, can I speak on bond then?
So
Because I think it's ridiculous the way I'm being.
Mr. Smith, since I can't do anything, I'm not going to do anything. I understand what you're requesting. I get all of that, but I need an updated report to try to figure all of that out.
But the thing about it is, I
heard
never wanted a competency exam.
I know you don't.
These lawyers are doing what they want to do.
Okay.
Nobody's communicating with me, and they're doing what they want to do. I wanted to speak on bond. Ain't nobody talk about when I'm getting out of this place because
well, you're not helping yourself with regard to that argument. Yeah, that kind of close that. So I'll adjourn this to November 13th. Why not? 2025, 9 a.m. It'll be a good week. Bond at this point will continue. Thank you. Thank you, Mr. Smith. We'll see you in a couple weeks.
Thank you, Your Honor.
Court does call the case of People versus Jarrell.
Kyle on behalf of Mr. Daryl Jarrell. Mr. Jarrell, please state your name for the court, please.
Good morning, Judge Simpson, Daryl Jarrell.
Welcome back.
Right, thank you.
And Your Honor, please.
So that we're clear, has Mr. Jarrell taken care of his other warrants?
Have you taken care of your
I
warrants?
have, I've addressed all
You
of
took
them.
care of the, okay. I just want to make sure because
Yes.
we don't need another thing like he did
Yeah,
last
thank
time.
you, thank
It's
you.
on top of everything.
Trying to avoid that subject.
Yeah, well, I am too, but you started it.
The confrontations I've had over that.
Well, you started. I didn't know why. I was trying to
Very,
be
very
nice to him.
humbling experience.
What did you say?
Very humbling experience.
Yes, it was, but we got past that. But I know that at some point you didn't appear on those and they were warrants, and I wanted to make sure they're clear. They're clear
Yeah.
for you. Okay,
So
good.
Judge, it sounds like me being appointed yesterday, I missed some excitement on this one. I'm also missing some.
Oh, there's a video.
Oh. So I'm sure it's viral.
That's okay. He can get it to you. No,
Yeah, that's some homework for you.
he's gonna
I
just
don't
shake
know
his head.
nothing.
Don't
That's exactly. Judge, we're just asking for an adjournment at this point. I was appointed yesterday, so he
Got
discovered it.
it. Okay. So adjourn the probable cause conference, but Mr. You're doing okay.
I'm on the right track now, Your Honor.
All right.
Thank you.
Probable cause conference, November 13th, 2025, 9 a.m. Bond continues.
Thank you, Judge.
Thank you.
I'll meet you on the hallway.
Court calls case, People versus Trita Guyton.
Trevor Mayville for the people.
Good morning, Your Honor. Mary Rubio on behalf of Ms. Guyton. I'm standing in for David Burgess with his permission. Is that correct, ma'am?
Yes, yes, ma'am.
Okay, please state your name.
Treat guy. Good morning, Mr.
Good morning. All right, you're asking for an adjournment?
Yes, Your Honor, we were just recently retained. I also would like to address bond when it's appropriate.
Probable cause conference will be adjourned to November sixth, 2025, 9 a.m. Yes, as to Bob.
Your Honor, it is my understanding that Ms. Guyton unfortunately failed to report to community corrections, and that's what has her in the situation she is in today. But I wanted to indicate a couple things. She indicates that she did call twice early on in October, and at that time, on 2 different days, she was told they did not have the paperwork and that she needed to call back. Ms. Guyton openly admitted she did not try to make any excuses. She said to me that she simply forgot. Ms. Guyton, unfortunately, has been diagnosed with lung cancer. She has received 1 round of radiation treatment. They have found another nodule. She needs to get more treatment. She's 63 years old. She also suffers from blood clots in one of her legs. I'm asking that the court would consider reinstating her bond. She understands the importance of complying with all terms of her bond, and she knows that she needs to follow up with community corrections.
Any response?
Your Honor, I want to note that my office did intend to extend a misdemeanor offer in this case. When looking at the ex-jail file, it looks like she has a couple of different holds, one on a case that was pled to RO attempted, as well as a minor misdemeanor hold out of Canton. Nothing else.
I'll grant the defendant's motion. Her bond will be modified. I'll reinstate the previous bond as set. Defendant needs to report over to community corrections. We'll need to prepare a new order for testing. You understand that, ma'am?
Yes, sir.
Thank you.
Thank you, Your Honor.
Court calls case People versus Alicia Allen.
That's thoughts for people.
Portia Feaster, Assistant Public Defender, on behalf of Miss Alicia Allen, who's standing to my right at the podium. Please state your name for the record.
Alicia Allen.
Thank you.
Thank you, Judge. We are requesting an adjournment on this matter for further negotiation, and Miss Allen would like me to address bond, please.
I'm sorry?
And Miss Allen would like me to address bond.
Gonna do it herself?
I think she wants.
She doesn't need you.
No, she doesn't really need me.
Okay, I'm just, okay. But, all right. What I will do, I'll adjourn this matter out to November sixth, 2025, 9 a.m. Yes, as to bond.
Thank you, Judge. I believe Miss Allen currently has a $35,000 bond. She is requesting of the court that the court consider a personal bond on this matter. She indicates that she is in or was in outpatient treatment prior to being incarcerated. She does hope to get this matter resolved. In the alternative, I am going to be requesting a release to treatment if the court is not inclined to grant her PR bond.
Response?
Your Honor, this is an OWI third. Her priors are from 2019 to 2024. At the time that she was pulled over by the police, she had previously crashed into at least 1 vehicle while traveling between 50 and 100 miles per hour on eastbound I-94 from Jackson County, coming into Washtenaw County. A 13-year-old child was also in the vehicle with her while she was operating at a .118. There is an RNO causing injury attached to this as well as another RNO. I do not believe any change to bond is appropriate. I would even be concerned with a release to treatment given the allegations here and the lack of compliance with lawful orders. I would ask that the court continue the bond as currently set and we can revisit a release to treatment at a later time. But I am very concerned about her being out of custody in any way, shape, or form in this.
Anything additional, Mr.
No, Judge.
Given all of that, motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Court calls the cases of the People versus Mohammed Murphy.
Thoughts to the people.
State your name for the record, sir.
Muhammad Murphy.
Thank you. What are we doing? Apparently, we're having a conversation.
Your Honor, we would like to set this matter for preliminary examination, and we'd also like to address bond.
Oh. This apparently doesn't carry over there. Mr. Kilowatt, I think one of these cases are yours.
Oh, yeah, that's true.
Sorry. Mr. Mohammed Murphy?
Yes.
Yeah, no, I know that's you, but on case 1701, you were.
I'm not aware of it. If you say.
Well, that's apparent. I'm informing you, I signed the order that the PD's withdrawn on that case, and it's you.
You know what? It's my lucky day. Good morning.
How you doing?
Do you mind if I ask for an adjournment so I can talk with you at the jail?
How long that's gonna be?
Well, we'll get it as quickly as possible, Judge.
No, I would rather handle this today.
Well,
because he said that it's been withdrawn.
Okay, hold on one second.
I
Nothing's all this.
just want to go home.
Judge, I wonder if we could pass this. I can go see him in the lockup.
Please. Okay.
You being a considerate judge, you are.
Thank you.
Do you have any objection to that, Ms. Akinruli?
Absolutely not, yeah.
All right, thank you. Okay, I'm gonna pass your case. They'll come back and talk to you.
Okay.
We'll get it all sorted out. You're welcome.
More than one case? What do I?
Let's call the case People versus Mohammed Murphy.
Pastor Feltus for the people.
Seriously. I need Kilowald and I need Akinruli.
Oh, I'm sorry. I'm sorry, I was trying. Assistant Public Defender, Tanaji K. Akinruli, Your Honor, on behalf of Mr. Mohammed
Morning, Robert J. Killen, behalf of Mr. Murphy.
Murphy.
Murphy, would you state your name for the record?
I'm in Murphy.
Judge, we discussed this matter with Mr. Murphy. It's our understanding he has holds in other counties. We're asking to set these matters for a preliminary exam.
That is correct, Your Honor. Mr. Murphy would also like for us to address bond, Judge.
So you want both these matters set for preliminary exam?
Right.
Well, you'll get the discovery, so discovery is not, but you'll get it.
It is not complete, Your Honor. I will try and get over to Mr. Kilowald as soon as we can, but I haven't been able to get him everything just yet, of course, so. I still have the public defender on my file for the other case.
We'll get it, Judge.
All right, but if a discovery issue is not going to be the basis for an adjournment, you understand that?
Judge, you can count on me, I'll handle it.
Well, all right. On your case, Ms. Akinruli, you have discovery.
We do, Your Honor.
All right. People have their witnesses available the 4th.
We'll try for that date.
Preliminary examination in person, November 4th, 2025, 9 a.m. That's before Judge Fresh Hour on both cases. Bond continued.
Judge, our client wanted us to address bond.
Oh, go ahead.
Your Honor, he is indicating that he would like for the court to offer him a PR bond. We have explained to him that he does have a few holds out of county. The ex-jail system doesn't tell us or indicate to us what those counties intend to do, if they want to advise and release, or if they would like for us to hold them, hold Mr. Murphy. However, Your Honor, he's asking that the court consider giving him a PR bond. He said he does have family who lives here locally, who he will be living with. He wants us to report or remind the court that the nature of these offenses are not very, very serious in nature, and that they're not violent offenses.
Well, they are.
I
I mean, there's an assault and battery and resisting and obstructing a police officer.
and
Go ahead. I'm sorry.
so, Your Honor, he wants us to consider, he wants the court to consider a PR bond.
Judge, I'd also say he's working with community mental health. He promises to keep working with them, and he will appear for all future.
I don't need a response. And looking at the file and looking at it, and the fact that he has other holds in other counties, at this time, the court is going to decline to change the defendant's bond. Defendant's bond for motion for bond reduction is denied.
Judge, are the bond in these matters only $100 each? That's what my client told me.
On the Ms. Akinruli's case, it's a 1,000 cash surety. Might be 10% on that, the way they had the form, but the other file, it is set at a 1,000 10%. On your case, it's a 1,000. Thank you. Court calls case, people, well, is he in? Got it. Court calls case, people versus Joshua Wara. Mr. LeBeau's case. Wara.
Joshua. Thank you, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
All right, well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know.
You
the
don't
mission
understand?
I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got
Klans.
to do something. I've got to
With
do
the
something with your
MDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you-
times
if
the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the fullest
I'm with you.
extent, which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing.
Mm-hmm.
I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom.
So you're here on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prism
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
which is actually 10 times the amount because I can sue because it's conspiracy to murder. And sovereign law would make it 100 times the amount, but since it is conspiracy
Okay.
to murder,
Well,
sovereign
I'm
law
with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count 2
amount.
on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of, that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Senator Johnson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No,
then
I do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen,
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any
on
point you
on
do,
objective
if
evidence. A
at
bench
any
trial
point
is
you
objective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on
A
subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder and Donald Trump and Elon Musk are involved and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can
amount of money that
I
they
don't know,
put
I've
the
not
hit
been
out
very
on
good at
me
it, but
and Donald Trump and Elon Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get.
Okay,
Mack
okay, I'm
and
with you.
Chair.
I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So
Donald
we would
Trump the
need more
elected
time.
chair.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do, sir.
Something.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, yeah.
Okay, but you
There are
haven't
too
seen
many
the
people involved.
You
have a
haven't seen
Neuralink in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
and based on
listen,
factual evidence, the jury trial
I
can be bribed.
hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Juarez.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
then.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, will we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Connor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would Man. I gotta add, I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm gonna give you your preliminary examination. So your preliminary examination will be set in person on.
Your Honor, I'm so used to
And,
just saying, yes, sir.
Adolf
No, I
Hitler
know,
is in
but I
judicial
realize it's
court
close, but
with Carol
it-
Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolf Mack. I'm giving him the electric chair. And I'm
Alright.
suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolf Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm gonna do.
And Donald Trump.
I don't know that we'll be able to go, given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolf Mack, JP Morgan.
I'm gonna set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome. No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir. Here goes the case. People versus Gregory Davis.
We're ready in that matter.
Mr. Davis, he wants all those people too? No?
Okay. I'm company, y'all.
What'd you say?
I am company.
Okay.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Gregory Davis. And for the record, Your Honor, I want Chase Bank too.
Well, apparently they're gonna be here too. So, come on, there's gonna be a whole lot of people here. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right, I have a plea form that indicates the defendant will be pleading to count 4, malicious destruction of property, 200 to 1,000, the 1-year offense, and 2 counts 5 and 6 of attempted resisting and obstructing, which are also 1-year offenses. Upon a successful plea to those charges, count Counts 1 through 3 would be dismissed. The sentencing judge waiver box is not checked. Was that meant to be checked? He understands this. I would not be sentencing him.
Right, he does understand that.
I understand, Your Honor.
So I'll check that box. All right, that's the clerk's full understanding of the agreement.
Thank you.
Is that right?
That is correct, Your Honor. That is our understanding as well. My client is ready to be sworn.
May I have him sworn, please?
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Lower your hand and state your name.
Gregory Renard Davis.
All right, sir, it is this court's understanding that you're going to plead to 3 misdemeanor charges. Is that correct?
Yes.
All right, the first charge is count 4, that being malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000, actually, I think that's a $2,000 fine plus court costs. And that, you understand that?
Yes.
You understand that the fine could be increased if 3 times the value of the property that's greater than $2,000, that would become the maximum penalty. You understand that? All right. And also that you're going to be pleading to counts 5 and 6, which are both attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14D District Court.
Yes, I understand.
Okay. Still wish to plead guilty?
Yes.
To the charge of malicious destruction of property, 200 to 1,000, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing contained in count 5, how do you plead?
Guilty.
To that same charge contained in count 6, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understand, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, I am on probation at Wayne County.
All right. Were you on probation at the time of this offense?
No, I was not.
You were not? Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, I am, Your Honor.
Of your own free will?
Yes, I am, Your Honor.
And because you believe that you are indeed guilty?
I am.
All right. On the date of March 17, 2025, at the location of 1409 Wingate Boulevard, Ypsilanti Township, Washtenaw County, State of Michigan, what did you do on that date involving the property of a Martha Freeman that makes you think that you're guilty?
I was inside the garage, Your Honor, and I damaged the mechanism from inside the handle from the door, trying to get back out the garage.
Okay, I'll ask, why were you in the garage?
I was going to get some things.
And you couldn't get out?
No, because the door went all the way down. I accidentally let it too far down as I was going underneath it and went down. And when I was on my way back, I didn't realize it was all the way down. So I had to break the mechanism from the handle from the inside, which is to release the wire part. And that's what I damaged to get the door back up.
Okay, were you supposed to be in the garage?
Somewhat I was.
I don't know what that means.
Did the garage belong to you, sir?
No, the garage did not belong to me.
Do you have permission to break the garage door?
I did not have permission to break the door.
And so you were getting things and trying to get out before somebody discovered that you were there?
Well, it's my mother's garage.
Oh.
And I damaged her garage. That's what I did. Because she couldn't let me out because her hands doesn't work, so she couldn't put the key in to make it work. So I had to accidentally damage it in order to get back out. And which I did, which is the handle from the door. The handle that turns outside of the garage, lets up.
No, I get it. But you. Okay, usually if this happened between a son and mother, there wouldn't be a problem and you would somehow fix the door or whatever. Why was this like this? Why?
Well, I guess officers of the Washtenaw County Sheriff was there for a disturbance of some sort. And I was outside and I was the first victim. So I guess that's how that happened. That's
You
what
were the first victim of what?
that they saw, I guess, of something. The disturbance that got them out there.
All right, sir.
That's when my resistance.
Sir, were you supposed to be in the garage?
Yes, I was out there in the garage, but I was trying to get out the garage. That's what I'm trying to say. I was not supposed to be there. I was in there too long.
Thank you. You were not supposed to at that moment be in the garage.
At that moment, I guess not, Your Honor. I was not.
And somebody then triggered the door to close you in because you wouldn't leave.
It wasn't the someone, it was me that closed myself in accidentally. I'm going in the yard, in the garage, Your Honor. I let the door up, and as I let it up, I didn't want to let it all the way up. I just
Did
let
you intentionally break the garage door?
Yes, I did, Your Honor. I intentionally to get out, I intentionally break it because there was nowhere else way to get out. And I damaged the mechanism that lets the door back up.
You know that if you go into the pathway of the garage door to go back up, never mind. I don't need to tell you that. You were okay. And so you intentionally broke the mechanism.
Yes, I did.
You
From
come out of the garage door. You then run into some deputies who had been called to the scene.
They wasn't called to the scene for that. They was called to the scene for whatever they was out there for, and I just so happened to be out there. So as they stopped me.
Someone want to help me because I'm not understanding this at all.
Did you, after you got out of the garage door, see police officers?
Yes, I did.
Did the
Numerous.
police officers give you orders?
Yes, they did. And
Did
I
you,
refused to follow those orders when they asked. That's what I did.
Did you know they were police officers?
Yes.
Did you understand they were acting in the scope of their duties?
Lawfully, yes.
What did they tell you to do?
Step off the porch.
And so the police got called to that house.
No, they did
This
not, Your
should not be that hard.
According to the report, the police were called to the house by a neighbor who reported that Mr. Davis and his mother were arguing, and it sounded like she was telling him to leave and he was refusing to leave. That was why.
Thank you. And so then at that moment, she told you to leave. You weren't supposed to be in the garage.
Couldn't get out. When I got out, by damaging her mechanism.
At the point she told you to leave, you weren't supposed to be on the property because she told you to leave, right?
Yes.
Okay. At some point, you were in the garage because you locked yourself in the garage and couldn't leave.
Yes.
Somebody called the police about that or something else, right?
Yes.
And so then you broke the door to get out.
Yes.
Because you knew you weren't supposed to be there.
Yes.
Got it. And then you run into police, they give you a command, you refuse to follow their command, correct?
That is definitely correct.
All right. And then that's the point that didn't work out for you because you got arrested.
2 resisting arrests.
Yeah, and and you resisted them, right?
Yes.
All right. Sir, if I do accept your plea, I have to advise you, if between the time of my acceptance to your plea and the time of your sentence, you commit misconduct as defined under the Michigan court rules, that the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None yet.
I'm not.
Have I complied with the court rule? Painfully so, but have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, it would be proper.
People are satisfied.
Court will accept the defendant's plea to guilty to counts 4, 5, and 6. Counts 1 through 3 are dismissed. The pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
December 4th at 10 a.m.
December 4th, 2025, 10 a.m. That is before Judge Washington. Bond will. Thank you.
December 4th is your next court date.
No, please go.
That's not it.
Court calls the case of the people versus Corey Tucker.
Portia Feaster, Assistant
was
Public
that?
Defender, on behalf of Mr. Corey Tucker,
Okay.
stand to my right.
Yelling out in my courtroom. She better take herself out. That is not permitted here. Thank you. Otherwise, you'll be escorted out.
Please state your name for the record.
Corey Tucker. One moment. Yes, you may.
Put her in the apartment, which you can't do. But that's what's gonna happen today. And then we'll have to fight it by the way. Okay?
All right, record should reflect, we've had a bench conference in this case, and this gets kind of murky. The young woman that was kicked out of my court just now, my understanding that's a family member of the defendant.
That's my understanding, Judge. Yes, Judge.
She is no longer welcome in the courthouse. So she doesn't come down here, and let her know that if she does come down here, she'll be subject to arrest. After I concluded the case, my understanding is that the alleged victim is present in the courtroom as well as family members of the defendant. Family members of the defendant will remain in the courtroom until such time as the victim has left and she has properly left the building and is secured and or left the building. And then you are not to leave this courtroom except with my express permission. If you don't follow that order, then I'll have you taken into custody. Am I clear? Because I'm not having it today. Am I clear? What are we doing on this case? Well, first thing is there are two additional counts 4 and 5. As to the arraignment on those,
Judge, he's standing mute, wavering.
defendant having waived formal reading, standing mute, the court will enter a not guilty plea. And he wishes to set for preliminary examination.
Still, so you're not waiving your exam. You're having that. Sorry, Judge.
He wishes to set for preliminary examination.
Yes, please, Judge.
Would the people have their witnesses available to fourth?
Yes.
Set preliminary examination in this matter in person, November 4th, 2025. That will be at 9 a.m. before
Judge Perry.
Judge Perry. Esteban.
Your Honor, at this time, I would be asking that the defendant's phone privileges be revoked. It came to my understanding that he has been calling the apartment complex where the victim is residing, telling them he wants her evicted. So at this time, I'd be asking that they be revoked, given that he's using his phone privileges to harass the victim in this case. I don't think it's appropriate that he still has those privileges.
Sorry, Judge. Obviously, we do not have those calls yet. I think my client would like me to object, but he understands that the court is likely to suspend his privileges pending a hearing.
Right, but my understanding, and correct me if I'm wrong, but is that based upon his phone call in part, an incident happened at the apartment because his family went over there.
Correct, Your Honor.
That's what Ms. Zinda has notified us. We haven't heard that call, and my client says that's not the case. So I don't know for fact, Your Honor. We have not.
Well, how does his family end up over there?
Well, his mother normally does his Section 8 inspections.
Okay, but it was more than just his mother there.
Yes, his mother and his sister was there, I believe, Your Honor. And so they went to do the inspection per normal. They've been doing it for several years for him.
I've been there for 7, 8 years.
And so they.
Okay, well, here's part of the problem. If she's been and I'm just gonna say it out, but if she's been residing there but hasn't been on it, and you're the listed resident, then there could be the potential of fraud, which means everybody's out.
I'm getting the
So,
right now. We're putting on the door and all that. But she won't leave.
Because she won't leave.
She cussed the landlord out yesterday.
Hold on, sir. She didn't just bust into that apartment. So I'm not getting, look, I am not getting into that. I'm just indicating that these phone calls, these interactions can't occur.
I understand.
And if there's been some fraud committed, then everybody's gonna be out. That would not be my purview.
I told the landlord she can evict me.
Okay, if he keeps up. Well, never mind. I made my decision. Phone privileges are hereby ordered revoked. Anything further?
No, Judge. Thank you
Thank
very
you.
much. You can still call me.
All right. She needs to leave first and get out, and then Folks, once she's out, you need to let me know somehow, Miss Zenda, that she is out and secured, and then I will release that side. Court calls case of the people versus Justin Straight.
May vote for the people. First time.
Whose case is this? No, I'll wait. Oh. 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 Look. You don't worry about it.
Okay.
It's all Cannon's fault. Okay? You're good. Even though I had to wait. I know it had to be Miss Cannon delaying. Go ahead.
I am Renika Glenn requesting, I would like to request permission pursuant to court rule.
Didn't they? She didn't talk to you about anything. You're good. Don't worry about it, Mr. Starr. She didn't talk to you about anything, did she?
What did I do? It was
Huh?
quick. It was quick.
No, geez, oh Pete. This gets so, well, no, she didn't talk. You know what? You know what? You need.
It could be more than once.
What?
If you read that little court rule, the implication.
Oh, it could be more than once, but it's really up to the judge
It is.
that I only need it once per session. And she was just up here. Do not try to cover for what you did trying to send her up here to get her head chopped off. Jeez, Gannon, protect your intern at all costs. You're good. You've already asked permission. I am I am so happy I was able to grant it. So you can just go ahead, counsel.
Thank you. I am asking for an adjournment on behalf of my client, Mr. Straight.
Hearing no objection. Probable cause conference will be adjourned. Mr. Straight is like, I don't know what was going on. To November 13th, 2025.
Actually, Judge, our client.
Oh, so that's not good enough? Oh, so, no, go ahead.
No, our client has something else to take care of on the 13th as well as the 20th. So we can please have a date
Please.
after the 20th. Please.
You needed a date after the 20th.
Yes.
Set it. Then I will set it. That was very nice how you asked, counsel. Unlike your supervisor. I will adjourn this out to November 25th, 2025. That's a Tuesday. That will be it. No, that will be at 9. Right? That is at 9 a.m.
May I be heard for you, Ben?
You may.
Will you clarify for my benefit whether or not the defendant is currently testing or required to test?
I think that he is testing. His last test that I have here was October 20th.
Yes.
You did today too?
I did Monday, and I got a call Sunday from my number.
Okay,
I
so
went
the
down there
last,
Monday.
gotcha. So he's testing, because the last test I have a report of is the 20th.
I have a
And
report.
no, you're good. You're
Thank
good.
you, thank you.
You're good. That's, people start talking, that's how they get in trouble. And then their attorneys got to argue, try to keep them out of jail, and then it's a big old mess. You're good.
Okay,
You okay? You relaxing?
I'm good.
Because you stressed me out and you did her too. You're welcome. His bond will continue with its condition. Thank you, sir.
Thank you.
Oh, now she's coming up. Yes, you may approach. Geez, oh no, wow. No, she just launched. I didn't know what to do. Lee was about to draw down on it. It was a mess. I told you, Cannon, protect your intern at all costs. Court calls the case, People versus Leo Stringa.
On behalf of Mr. Stringa. Mr. Stringa, can you please say your name for the record?
Yeah, Leo Stringa. Good morning or afternoon at this point. Sorry.
Good afternoon, sir. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
He's gonna plead to an added count 3 of use of fentanyl, first offense, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Judge.
That's correct, Your Honor. Thank you.
Mr. Stringer, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Leo Stringer.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yeah. Yes.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form or had one signed on your behalf?
Yes.
That's the 2-page. Okay.
Do you have any questions regarding any of the rights that were explained to you?
No, my attorney did a good job of going over those with me.
And you understand that you're waiving those rights, sir?
Yes, Your Honor.
All right. You understand also you're giving up your right to appeal of right?
Yes.
Anybody, are you on probation or parole?
I'm not on either, but I think it's pending with
He's getting
with you, I
sentenced
believe, on
another
another case, Your Honor.
All right, but at the time of these offenses, you were not on probation or parole. Is that correct?
That is correct.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Unfortunately, yes.
All right. On July 29, 2025, at the location of 3135 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, did you have fentanyl in your possession?
Yes.
All right. Did you know you had it?
I didn't know it was fentanyl, but I knew it was an opiate.
Okay.
I don't know. Should I not say that?
All
for
right.
the
No,
plea?
that's fair enough. All right. And had you used it?
No, I didn't actually get the. No,
You
I
didn't
didn't.
get a chance, but you did possess it at that time.
Yes.
All right. So I could take the higher charge anyway. All right, sir. I do have to advise you, if you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, and you could not withdraw your plea. You understand that, sir?
Yes, sure.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have.
Defense is so satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me.
Okay, Your Honor, can I ask, just because of my medical situation, can we do that via Zoom as well?
You talk to your attorney and they will submit the proper paperwork and then we'll make a determination, okay?
I'll
Okay,
talk to you
thank
right
you, Your
after
Honor.
court, Mr. Stringer.
Thank you. Bond will continue.
Okay. All right, have a good day.
Thank you, Your Honor.
Thank you.
Thank you, counsel.
Thank you.
She didn't do anything. No. No, I'm sorry. No, you guys
She's
were
very
talking.
good.
I'm sorry.
She had an
I
hour
didn't mean-
conversation with me on the phone over the past week.
All right. Thank you, sir.
And about 100
Court
texts.
calls the
Have a
case
good day.
People versus. Court does call the case People versus Edward Byrne. Byrne.
Oh, that's you.
Good afternoon,
Oh, there
Your
he
Honor.
is. Hello, sir. All right. Okay, the AG is here. He's kind of, are you gonna put your appearance on? What are you doing?
Yes.
Okay, but wait.
Did you call
I
the
need to
case,
plan-
Judge? Did you give us a case number?
I didn't do the case number, but it's people of the state of Michigan versus Edward Byrne, 24F5 or 5314.
Good
Ranika
afternoon, Your
Glenn.
Honor. Go ahead, counsel.
Go ahead, counsel.
Good afternoon, Your Honor. I'm Special Assistant AG Mitchell Wood for the people.
Thank you. All right, now go ahead.
Good afternoon, Your Honor. Ranika Glenn on behalf of Mr. Byrne. Mr. Byrne, can you please state your name for the record?
He's muted and upside down. It's been a day.
Unmute.
Unmute and okay, you're still upside down, but that's okay. I'll just turn like this. Now he's not there. Where'd he go? Oh, there he is. Now we can't see you. Mr. Byrne, are you there?
I'm here. Can you see me?
Yep, we can. Never mind. You look good. All right.
Let's see how I look in an hour.
Oh, I don't know what
But
that
thank
means,
you.
but okay. So don't want to know. What are we doing?
I'm asking for an adjournment on behalf of my client, Mr. Byrne, for further negotiation.
All right. Any objection?
No, Judge, I did just send an offer email for both Mr. Byrne and Terrence Ginyard, the other person that I have today.
Okay.
Who is counsel again, please? Did I send it to you? Is this,
You'll have to send it to Miss Cannon. Her intern, this is her intern appearing.
Okay.
Who's done a fabulous job today.
Thank you.
And I did, I will be forwarding that to our clients.
I'm sorry, I didn't hear that.
She did that was Miss Cannon. She did receive the email. She'll be forwarding it along to her client.
Very well. And
All right.
Judge, I don't have a problem with an adjournment in this matter. I would note, Judge, that again, I sent an offer letter. I was just sending another email to Miss Cannon to let her know that Mr. Byrne's arrearage when the AG charged him was $10,827, but he has a pretty high monthly amount, $1,041 per month for two children, and he's only made one $30 payment since the onset of the case. So oftentimes the AG would ask for an increased bond, cash bond, to be consistent with the statute. So that's something we can adjourn this and she can take that up. I mean, I'd be happy to talk to her. She can take it up with Miss Brenner, who's the attorney of record. I think Miss Brenner's covering Washington now. But in any event, I don't have a problem with an adjournment, Judge, but the defendant needs to start paying as ordered. He made one $30 payment since the onset of the case.
I made a payment yesterday of $750.
Well, that's good. All right, that's good, Judge. He's almost to 10,041.
And sir, I have Cash App and Venmo statements. I sent my attorney over $2,000 that I paid my kids.
Judge, we don't need to get into this, but if he's talking about a direct payment, that's a whole different deal. You know, payments are made through the front of the court system, or
They should be to the front of the court. All right, sir, I'm going to let you talk to your attorney about that. I'm going to adjourn this out a bit so that you can have that figured out. But do understand that if I see that payments haven't been made and that the arrearage is growing, that I will strongly consider an increase in the bond to be commensurate with the statute. You understand that, sir?
Yes, I do, and I understand. I'll do what it takes to not have a felony on my record. worked on Wall Street 34 years. I'll lose my job tomorrow if I have a felony.
And that takes about 11 grand, but we'll worry about that later. All right. I'll adjourn this out to the 13th, so because it looks like they've got a lot more to talk about than November 13th, 2005, 9 o'clock, or as your invite indicates, bond will continue.
Thank you, Your Honor.
Young lady, you had no idea what went on, did you? Okay, never mind. He just stood there quietly. Court calls case, People versus Colette Haynes.
Here, she's with the prosecutor here on behalf of the people.
Carolyn Foster Tucker on behalf of Colette Haynes. You state your name.
Colette Haynes.
All right.
Thank you. In regards to the PCC, Your Honor, we are requesting an adjournment just for some continued negotiations.
All right. With reference to the violation.
Yes, Your Honor. Ms. Haynes is prepared to admit to the bond violation today and provide an explanation.
All right. I'll accept the admission, but what's the explanation?
Your Honor, it does state in the bond violation report that on the 22nd, when she reported she was visibly ill at the time, she explained to me that she has diabetes and shortly after that went into DKA and did have to be hospitalized for a few days. So unfortunately, she ended up missing that new scheduled appointment as well as her first PCC. After missing the PCC, she did contact me and we worked to get this case set to do a bench warrant recall. So she is willing to test. She is willing to comply on bond. She is sorry that she missed that appointment and she's hoping to have an opportunity to go touch base with community corrections today and reschedule.
Thank you.
But okay, I hear what you're saying, but when I look at this, all of the events that I have in this occurred at basically toward the end of September.
Yes, Your Honor.
I'm now almost 30 days out and nothing's been corrected.
And Ms. Haynes indicated to me that she wasn't aware that she needed to make contact with community corrections because she had the bench warrant.
I didn't know that I can just go back there and.
Yeah, but once the bench warrant was cleared, that doesn't even make any sense to me.
They told me that I had to wait when first they told me I had to do it online.
Do what online?
For the bench warrant.
That's fine.
Yeah, and I didn't know that the warrant was cleared until I come to court today. And
What do
I
you
thought
mean
I
you
needed
didn't know it was cleared?
Another referral to go back to community corrections. I didn't know I could just walk back in there and do it all over again with a warrant. I tried to come up here and walk in on a warrant, but they told me that they only do it once a month. At the end of the month on Wednesdays. And that would have been yesterday, but I had received
Yeah, but where were you between that? All of this occurred September 2nd. I get what counsel's telling me that at some point you're in the hospital for a few days. So even if that takes me to the end of September, which is giving a lot of grace just in terms of time, I'm now here on the 23rd and nothing.
Because they told me that I could not walk in on the warrant. And I didn't know that I could just go back to community corrections.
You have an attorney.
Mm-hmm.
And Your Honor,
I was contacting the attorney, and when I was contacting the attorney, she was telling me that she didn't even, well, it was a he. It wasn't even her. It was a whole different attorney I had. We were texting back and forth and I was asking him questions and he was saying he was in court. He don't know, he'll find out. And then he told me I could do it online, so I just did it online.
and Your Honor, I will say Ms. Haynes does want to resolve this case. She did make steps to take care of the bench warrant and to get the case back on track. So she's just hoping for another opportunity
She
to.
hasn't, she's hearing the drug case. Since the beginning of the case, she hasn't tested.
Understood, Your Honor.
I hadn't tested, Your Honor, because I didn't know that I could just, by me missing mine, I didn't know that I could just go walk back in. I thought I needed another referral. Or I would have went over there and walked in and
It's
tested.
not as though you didn't have an attorney, whether it be the previous attorney, whether it be Ms. Foster Tucker, to tell you what you could do regarding community corrections, if anything. But, you didn't abide by community corrections. You didn't appear in court. You get the court thing cleared up, but then you had the other thing, and I still, for the time of year, I don't have a test on you.
I can go take one today. I can go over there right now when I leave here. But I just need to know, am I
Anything you want to
assigned?
say, I will adjourn her probable cause conference to October 30th, 2025, 9 a.m. Anything you want to say before I send you on the violation?
No, sir.
Well, at this point, she's not complied with everything. I'm going to revoke her bond, sentence her to 7 days, Washington County Jail. Defendants remanded.
Is there a way that I can get somebody? I have my daughter here with me,
Ma'am, you probably shouldn't have done that.
but she only had a half a day of school
Here,
today.
ma'am,
Come on this way.
they'll figure it out.
I'll give it.
Ma'am, go with my bailiff now. Now. Court calls case People versus Jay Snyder.
Ready, Your Honor. Good afternoon, Your Honor. May it please the court. My name is Ben Savage and I represent Mr. Snyder. Jay, state your name for the record.
Jay Snyder.
All right, what are we doing?
Your Honor, is the court receiving the plea form in this case?
I am.
The defendant will be pleading guilty to currently charged count 2, objects littering, basically in the path of vehicles is basically what the charges. Count 1 will be dismissed. There's an agreement that the defendant pay restitution. He has paid all of the restitution already, which is the impetus for the plea.
Got it.
That is correct, Your Honor.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
State your name again.
Jay Snyder.
All right, you can put your hand down. Sir, it is this court's understanding you're going to plead guilty to the charge of littering objects in the path of a vehicle. That's a misdemeanor punishable by up to 1 year incarceration and or a $500 fine plus court costs. You understand that?
Yes, Your Honor.
Still, I should also advise you that while I'm taking your plea and not checked on this form was the sentencing judge waiver. You understand that I will check that. I think there's a form in here regarding that.
Yes, Your Honor, I did go over that. I forgot to check it when I
Got it. That's
my client is aware of that.
I forgot to go apologize, Your Honor.
all right. So, sir, you understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
You can't be my judge, Your Honor.
Sometimes you may not want that, but no, you go to Judge Barr. Judge Barr is a great judge.
Okay, Your Honor.
Judge, I didn't prep him for that, but that was pretty good.
No, now he's my favorite. All right. So you understand you'll be sentenced before Judge Barr?
Yes, Your Honor.
All right. So to that charge, sir, how do you plead?
Guilty, Your Honor.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
Oh, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation in Wayne County, Your Honor.
All right. Were you on probation at the time of this offense?
I was, Your Honor.
You were?
No, wait. I wasn't.
I
I wasn't.
Okay, I'm not his lawyer on that case, but I'm pretty sure he was not, but I'm gonna look
You
into
don't
that.
think that you were?
No, I know for a fact I'm not. I wasn't.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Fine, all right. This file's a mess. All right, let's do it this way. All right, sir. On July 5th, 2024, at the location of Stony Creek near Willis Road, Augusta Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. And what'd you do that makes you think that you're guilty of this offense?
Well, I was littering, Your Honor.
So you were throwing things out your window?
Yes, Your Honor.
All right. And were there other vehicles on the road?
Yes, Your Honor.
All right. And some of these objects that you threw went into the path or what would be the path of those vehicles?
Yes, Your Honor.
All right. Sir, if I accept your plea in this case, you understand that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that the court would not be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's?
We're satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty. Count two, count one is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be November 18th, 2025, 10 a.m.
Yes.
10 a.m. before judgment.
Your Honor, is it possible to get a different date? Or do I need to
You
go
would
to?
have to contact the 1482 district court. They can
I
do that.
thank you, Your Honor.
All right. Bond will continue.
Thank you.
Thank you.